First case of the morning is State v. Leneo. If I'm saying Leneo wrong, I apologize. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
5 minutes, please.
Thank you. As you know, time will be over there. Please try to look at that top circle for you, and counsel, please look at that middle circle. I'll try to let each of you know when there's a minute left in your time in case we are bothering you with questions and you lose track of it. Arguments are being recorded. When you present your arguments, please introduce yourself, keep your voice up, and remain behind the podium. If you're using the name of any child or victim, please make sure you use initials or some other designation. We have read your brief and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellant in this matter. We are asking that this court reverse the trial court's decision granting the defendant's motion to suppress. The standard of review, of course, for a motion to suppress is that it presents a mixed question of law and fact. The state respectfully submits that the trial court's findings of fact are not supported by competent, credible evidence. As articulated by opposing counsel, the state does disagree essentially with what the trial court found, and we're simply asking this court to review the body camera footage that was submitted for the 2 officers, as well as the testimony of the 1 officer who was permitted to testify at the suppression hearing, and to independently determine whether or not there is competent, credible evidence to support the trial court's finding. The state would submit that when you look at the body camera footage, it does support what the officer said. It doesn't show all the things that the officer said. However, through just everyday life, we all know that there are times when our eyes can see something that when we try to record it, it does not necessarily get picked up, especially when there's glare or tinted windows. In this particular case, the officer testified that the vehicle had made a traffic violation, stopping without a signal, did a rolling stop, increased speed, then did an illegal U-turn. The officers felt that there were furtive movements. Again, only 1 officer was able to testify, indicating that the defendant's hands had gone up and down between the driver's seat and the center console, and that based on that, they were afraid for the fact that there could be a weapon and or evidence being destroyed, so they quickly went up on the scene. The body camera footage, of course...
Did the officer testify about any concerns about evidence being destroyed, or was his concern more about safety of the officers?
He said safety of the officers or evidence being destroyed. It was clear they were more concerned about there possibly being a weapon in the car, which, of course, there was a weapon in the car. The fact that it was correct, of course, doesn't go into whether or not there was.
That being the case, when we're looking at the question of the officer's safety, what is the standard the officers need to have to search under those circumstances?
If they believe that there's a weapon and they could be in danger, and the issue was that this officer, it was just a minor traffic violation, so the person...
What is the probable cause of reasonable articulable suspicion, I guess, is my question.
Yes.
What is the correct standard for the court to determine for the officers what the officers have to feel to be able to do the search?
You mean whether it's an articulable suspicion or something different? I would say they just have to articulate that reasonable suspicion that there was a firearm in the vehicle and that it posed a danger to them to do a protective sweep. I don't think that there's a higher standard than that is required.
So it would fall under Terry and Michigan was law in those cases?
Yes, sure.
Is that the standard the trial court applied in this case?
I believe that is the standard that the trial court applied in this case. I don't believe that the court made any error with the analysis of the law. The only issue that we had was with the finding of fact that, 1, the officer's testimony was incredible simply because the body camera footage didn't reflect everything that the officer testified to. The officers, there's no way body camera footage or even dash camera footage is always going to reflect every single thing that someone sees or someone feels. We certainly can be watching something in the moment and have, a suspicion or be able to articulate why we were afraid of something, and when you go back and look at it, perhaps that isn't what was going on because they're in the heat of the moment. There's no dash cam that would have caught some of the things that the officer testified to, so it's unfair to say because it wasn't picked up on body cam that wasn't initiated until after the stop that those things aren't in the record, is the crux of our argument. There was nothing that was indicated by Officer Wood to say that he lacked credibility. In my opinion, which that is all that it is, right? It's not in the record. It's just kind of when you read it, we had 1 officer who was outside the door of the courtroom, and it was concluded by the court that that officer had violated separation of witnesses and was listening in. And I think that put some taint over both officers' credibility. But that isn't supported by the record, right? Maybe the officer wasn't permitted to testify, had some potentially, right, a reason to say there was some lack of credibility. Perhaps, I'm not saying that there was, but perhaps. But this particular officer who was on the stand, there's nothing in his testimony that was presented to the court that should have caused the court to disregard his testimony about what he saw as far as furtive movements. You can see on the camera, even through the tinted windows and the glare, you can see some of the gauge and you can see some hand movement. I would not say what you see is furtive movement, but you see some.
When are we talking about, we'll look at the video, when the officer is running up to the car?
Right.
Can you see anything of the passenger in the car in those few seconds?
You can't see anything until he gets right up to the car.
So during that time, is that the time the officer said he saw furtive movement when he was running up to the car?
When he runs up to the car, right. What he sees with his eyes, you cannot see on the body cam footage.
And did the trial court find him specifically to be not credible, or did they just say the videotape doesn't match what he said?
It was a little bit of both. It was, we don't see this, and therefore he's not credible. So kind of a little bit of both. The finding of the facts are not, kind of delineated out. I find fact this, fact that. It's more of, when you look at the video footage, because of the glare and the tint, you can't see anything. Therefore, his testimony that he could see it isn't credible. So I know they point out that the way I articulate what the findings of fact are not the same as the way they view it. So there is some, I would say, interpretation as to the specific findings of the fact. But no matter how you take it, whether you say it's a specific finding that you couldn't see through the window, which is part of what's in the court's finding, you can see some things through the window. And it is just factual that when your eyes and what's caught on camera, due to lighting and tinted windows and all of those things, may not be the same. That doesn't mean that what you're testifying you saw is not credible or did not happen.
If we say that the trial court's finding that there were no furtive movements was competent credible evidence, is supported by competent credible evidence, are there other reasons to justify the officer's search in this case?
You would have to find that the officer's testimony that they evaded and that they had concern for the weapon. Without the furtive movement, it would be a tough call to say that based on an officer's testimony that there was some evading after they attempted the stop. So I would say no. If you don't find that there is the officer's testimony about furtive movements, it was competent, credible evidence in the record based on the officer's testimony, then I would say there's not enough to say they should have done a patrol sweep. I think that's fair. So the state is just asking that the court independently look at the video, independently look at what the officer testified to, and determine if there's competent, credible evidence. We're just looking for that higher review, and we would acknowledge that we see it differently than the court and we see it different than opposing counsel, and we're just asking for the court to look at it. If there are no further questions, I would rest my case. Thank you.
You'll have your full time for a vote.
Good morning, Your Honors. May I please the court? Joseph Schell from Summit Legal Defenders on behalf of the App.No, Mr. Chris Leneo. Well, so it sounds like I think there's actually a lot of agreement between us and the state about what exactly the officer testified to, what the trial court found, and really I think the difference here comes down to the standard. Judge Stevenson, you asked about what is the standard that we're looking for, number one, for officer safety. And under Michigan versus Long, what there needs to be in the record is some concrete articulable fact specific to Mr. Leneo that gave the officer an objective reason to think that he had a weapon, not just a hunch.
It's a Terry standard and not a probable cause standard like in Kessler.
That's right. That's right. It is a lower standard. It does still require something specific and concrete, though, that the officer can point to it, or that even the trial court can point to in the record to demonstrate that this person was armed and dangerous.
Did the trial court, however, decide this case on probable cause rather than a reasonable articulable suspicion?
So I think it explicitly did say something about probable cause because it, invoked the Kessler standard, and I think in its conclusion on granting the motion did explicitly say probable cause, but there's other parts of the trial court's rationale that suggest it was talking about both. It said there's no reason to justify the search. And had there been a reason to justify the search, it could have said, there was a reason for a protective sweep here. But even under that lower standard, there are no concrete facts here that suggest Mr. Leneo was armed and dangerous. He has no prior criminal record. The police knew that by the time they picked him up because, as Officer Wood testified, they had time in the few blocks that they were following him before they turned the lights on to run his vehicle's history, to pull up his history. They knew he had no criminal record at that time.
Am I correct when I look through the exhibits that are the videotape exhibits?
Yeah.
There is no exhibit that I can see how the defendant was driving in this case. Everything is just the dash cam or the dashboard and nothing going out from the car.
That's right. Yeah, it's just the two officers' body cam videos, and they pick up Officer Wood's video specifically right before they turn the lights on, and that's right before Mr. Leneo pulls over.
We can see from that the video, that the lights are turned on and almost immediately thereafter the defendant pulled over.
Yes, that's right. But you're right, there's no video of what he was doing before. What the trial court said about that is even if I believe what Officer Wood said about what he was doing before, the body cam footage shows that whatever he was doing, he wasn't evading the police because he didn't even know that the police were behind him. And that's not...
Officer Woods testified that we're in a marked car, obviously, and when we're in a marked police car, we have lights and everything. We haven't turned them on yet, but it's a well-lit area, and someone should be able to tell that's a police car behind them. And the court never really wrestled with that. The court just seemed to say, well, when they turn the lights on, that's the only way they could have known they're being followed by police. Is it certainly possible that that this gentleman could have known that police were following him based upon the nature of the car?
I suppose in the abstract it's possible someone could see that, but Mr. Leneo's statements on the body cam to the police, which the police accepted in the moment, and this is at about 1 minute and 15 seconds to about 1 minute and 40 seconds in Officer Wood's body cam video. What he said was, I did think someone was following me, right? Like that's why I sort of doubled back. I did think someone was following me. I didn't know that it was the police until you turned your lights on, and then I immediately pulled over. And even in that moment, Officer Ripka says, yeah, we get that. And a few minutes later, Officer Wood confirms, right? Yeah, we get where Mr. Leneo is coming from, that he didn't know it was the police until we turned the lights on. So there's nothing illegal about driving away from the police when they're not asking you to stop. Mr. Leneo pulled over here immediately once they turned the lights on and signaled to him that he should stop. But even if he knew that it was the police, let's say that he knew that was the case, nothing about that is a concrete fact that Mr. Leneo was armed and dangerous.
Counsel, can I go to that factor that you're thinking, that you keep repeating, and that is in regard to the concrete fact? And the court says specifically, the issue hinges on whether a reasonably prudent man in the circumstances would be warranted in the belief that his safety or that of others was in danger. Do you think that that's an incorrect standard?
I guess so far as reasonably imprudent man should probably be reasonably imprudent police officer. I think that's probably the only correction to that, but no, I think that's right.
It doesn't mention a concrete fact there. That's what I'm trying to say, though.
Well, so that comes from Michigan.
I understand, Michigan versus Long.
Yeah.
Go ahead.
Yeah, so that comes from Long. So I think, Your Honor, I think that's the standard from Bobo that you're quoting there from the Ohio Supreme Court.
I'm just quoting the trial court right now.
Okay, yeah, so I think so the court is, I believe, getting that from State versus Bobo. I think that is generally the correct standard for what you're looking for. Michigan versus Long, Terry versus Ohio made clear that for these things, what you need is some specific reason to think that this person is armed and dangerous.
Well,
and so,
under the totality of the circumstances, it seems to be.
Correct.
And it doesn't seem to be necessarily, it has to be like one concrete fact, but the totality of the circumstances, a reasonable officer would make the determination that he needed to sweep for officer safety.
So I think both of those things are right? I think it is a totality of the circumstances analysis. There does need to be something, though, something concrete that you can point to that says, I had a reason to think that this person was armed and dangerous, and that's why I needed to do a protective sweep, not that I searched for some other reason. And here there's nothing, even assuming that there were some traffic violations, right? We're not challenging that there was cause for the stop.
Officer also testified that he was acting nervous. after this, into that potentially one of the circumstances, when we look at the totality of circumstances, it can lead to a protective sweep?
I think excessive nervousness is what's required. I think because everyone's generally a little nervous when they get pulled over by the police. And I think, even Officer Wood agreed with that here in his testimony.
Would the officer's testimony here that he observed what he felt was excessive nervousness, or did he in any way say what he felt about the level of nervousness for this particular defendant?
No, I think he just said that he was nervous, that he seemed to be nervous, right? I don't remember that the officer saying anything explicitly about him being excessively nervous. I think he did mention that he thought Mr. Leneo was breathing heavily. I think that just goes to general nervousness. But nothing about Mr. Leneo's interactions with the officers here suggested that he was hiding something, suggested that he was hesitant to comply. He had his hands up immediately when he pulled into the driveway. You can't see him do anything on the body cam footage.
We can see when the officer gets beside.
Yes.
At that point in time. That is, would you agree that's the first time we can really see the defendant clearly? In other words, when we're running up, the officer runs up behind, we can't really see in the car and see anything that's going on in the car.
That's right.
You would say that's a fair view of that 2 seconds or so that occurs.
Absolutely, yeah. I think you can't see.
And then when we get next to the car, then we can start seeing some movement inside the vehicle.
So I'm not sure I agree we can see some movement. We can certainly see Mr. Leneo's left hand up. The window the officer asks him to roll the window down. He lowers his left hand to roll the window down. He puts his hands back up after that.
So we see movement. It may have been in response to the officer's directions.
Absolutely.
Roll the window down.
Yep.
Down. We can see the left hand, probably not the right hand particularly well when the window's up. The window comes down, we can see the hands and him moving them. And I think you would say from your brief, at the direction of the officer, that's what his movement.
That's right. Yes, I think he only moves his hands at the directions of the officers. To put the window down, I think the officer says, "Put your hands on your head," instead he places them, in front of the dashboard. And then the officer asks him to get out, and he reaches for the door handle. So yes, I think the only movements that we can see from his hands are in response to the officer's instructions about what to do.
How do we deal with the fact that the court found there were no furtive movements when he ran up to the car, when we just can't see in the car and have no idea what was going on in the car at that point in time?
So I want to be careful about what the trial court found. I don't know that it found explicitly that there were no furtive movements. What it found is that it didn't see any credible evidence to support Officer Wood's testimony that Mr. Leneo was moving furtively at any point. And I think part of that is because you can't see what Mr. Leneo was doing in the car. The other part of that is based on just like how fast it is, how that Officer Wood gets out of the car, moves past the trunk, gets up to the side window. Part of it is that Officer Wood's story changed from direct to cross-examination. On direct, he said, he was asked by the prosecutor, now, what did you see when you got up to the driver's side window? And he said, that's when I saw these furtive movements of him abruptly, frantically shoving something down between the seat. But on cross-examination, once defense counsel walked through the video, sort of frame by frame in slow motion, then Officer Wood's testimony changes and says, no, I saw them when I was running up from behind. So I think,
that was only a matter of a couple seconds, though.
Matter of a couple seconds, but it is a change in his story, and I think that speaks to the officer's credibility, and at least it's at least competent, credible evidence for the trial court to find that the officer's testimony was
I'm sorry, I know you're running out of time. Can I follow up with Judge Stevenson's question? The court says the body camera footage contradicts the statements of the officer. If we can't see what's going on, if in the video you can't really see inside the vehicle, how does that contradict the officer's statements?
So I think particularly because, again, the officer testified at first, at least on direct, that he saw furtive movements at the driver's side window. You can watch the body cam video and there's no reasonable basis for saying there's furtive movements there because you can see his hands at that point. So I think that's a contradiction. I think at one point on pages 32 to 34 of the transcript, Officer Wood suggests that you can see Mr. Leneo's furtive movements from the back of the car in the body cam footage. That's not possible when you watch.
Let me just stop you. I haven't read the transcript yet. So the officer testified that when he was viewing the video in court, that he could see the movements.
Yeah, not explicit. He doesn't say like right there you can see it. He does suggest that on cross at pages 32 to 34. And I think even the state takes his testimony to be that like right. Let's what he says. Slow it down. I'll walk you through it. You can see where he's moving, and that's just not possible from the body cam footage. So those are I think the contradictions. Even if the contradiction finding though isn't. Even if the court says, well, we don't think that it was contradicted, there's still plenty of evidence in the record to support what the trial court found about whether there were some concrete facts that suggested that Mr. Leneo was armed and dangerous or whether there was probable cause to search. And that is the standard. So not, as the state said today, the standard is not whether there's some evidence to support the state's position. The test is whether there's any competent, credible evidence in the record to support the trial court's factual findings. And again, based on what we've talked about here, the contradictory testimony, the changing story, viewing the body cam footage itself, all of those things support what the trial court found. The trial court says, the officer is on Mr. Leneo in mere seconds. That's supported by the body cam in the first 10 seconds. It says that there's, flashlight glare and that the windows are tinted. Those things you can see in the body cam footage as well. And that once Officer Wood gets to Mr. Leneo's driver's side window, that you can see that his hands are up and that he complies with the officer's instructions. All of those things are supported by the record. So not only is there competent, credible evidence to support what the trial court found, it correctly applied those things to the law. Again, the state has reiterated here, it makes no challenge to the trial court's legal analysis. So I think that means even setting aside the challenged factual findings that it's made from the trial court, there is still no justification for the search because furtive movements alone don't give you probable cause. Furtive movements alone don't give you reasonable articulable suspicion unless they suggest that he was armed and dangerous. And there's really nothing like that here. Officer Wood over and over says, well, we didn't know whether it was this. It could have been that he was destroying evidence. It could have been that he had a weapon. But he doesn't point to anything, that says anything like what we saw in Kessler, like, oh, this person was previously involved in firearm-related crimes or violent crimes or anything like that. It's just this person rolled a stop sign, didn't use his turn signal, and pulled into a driveway. Therefore, I think he's armed and dangerous. That falls well beneath the standard.
You can't completely ignore the time of day, the high crime area. Those factors still come in for the totality of the circumstances, right?
Absolutely. We're not asking the court to ignore those, and I don't think the trial court did.
So you just don't have furtive movements, is what I'm trying to say, though.
Either. Well, you don't have any concrete fact that, you don't have anything particular that Mr. Leneo was armed and dangerous. So, all of the things I think that Your Honor is talking about, the time of day, where it is, those would apply to any motorist on the street. It would apply to really anybody, even who made a U-turn or rolled a stop sign or, didn't use their turn signal. But there's nothing.
A minute left, counsel. Sorry to interrupt.
Thank you, Your Honor. But there's nothing, that says Mr. Leneo that because he did those things, right? I don't think there's no authority in the state, certainly doesn't point to any, for the authority that not using your turn signal or making a U-turn gives the police reason to think that you might have a gun in the car. There has to be something else particular to Mr. Leneo that does that, and there's nothing here. The standard is highly deferential here to the trial court. The trial court is, as the fact finder here, can evaluate the credibility of the witnesses, is free to accept or reject any testimony, really for any reason. It can even reject uncontroverted testimony, as this court has said before in the cases cited in the briefs. And particularly when there are things here where there are things in the record that support the trial court's findings.
Thank you, Your Honor. You have your 5 minutes for a vote.
Thank you. May it please the court. Just briefly, I would like to reiterate that the state would respectfully ask this court to look at the totality of the circumstances and under the totality of the circumstances to review the testimony of Officer Woods, which talked about the defendant was nervous, he had rapid breathing. They described the furtive movement as being frantic, up and down movement. The officer mentioned the time of the night. He also mentioned that he believed that there was a weapon in the car and he asked the defendant to put his hand on his head, and instead of doing that, he put his hands on the wheel, which of course would be closer to the area where there was believed to be a gun. And we would argue that the video does not contradict the statement of the officer. And just lastly, in closing, I would ask this court to not accept an invitation to make a bright line rule of some sort to say that an officer has to have concrete facts that someone is armed and dangerous before they would be able to do a protective sweep to protect their life and limb. That would put officers in an untenable and very dangerous situation, and it is not the standard of the law.
Counsel, let me just ask you, if if the videotape doesn't show anything either way, you can't really rely on it, what prevents the court from just saying, I don't believe the officer, which it seems like the court's saying here?
Right, I believe that under the case law, the court has to articulate a basis to not believe an officer, just like any other witness. There has to be a reason to not find that they're credible. When someone comes in and testifies and you're not articulating a basis for it, whatever it might be, if they're not looking you in the eye, whatever causes you to believe that there's some reason to find that they're lacking credibility, that should be in the record. And that just simply isn't here. The indication from the court was that there's some belief that the officer was incredible because the testimony, in the court's opinion, contradicted what the officer testified to, and the state respectfully submits that it does not contradict. Everything the officer testified to is clearly not on the body camera footage. It never is.
Counsel, what about the change from direct testimony to cross-examination?
I don't believe that that's a change in the testimony. I believe that's a clarification, and it would have been even less than seconds of as I ran up and then when I got to the window is what I saw. And I think any of us can, remember something, and then when you go back and look at the video footage, say, oh, that was actually 1 nanosecond different than when I thought it was. I don't think it's enough of a change to say it was a change in testimony. I think it's just a clarification.
Was the officer trying to say there was furtive movements once he got to the side of the car by reaching down to put the window down and reaching down to open the door, putting her hands here rather than here?
Did not say that. Just said that the reason why I believed he was armed, that there was a firearm in the car, part of that was the fact that he wasn't listening to, I said, put your hands on your head, and he put it on the wheel. So that was going to the belief that they were armed, not to the fact about a furtive movement, to kind of split hairs on that.
And counsel, what about the point of evading the officers? Where did that come in?
As far as the timeline or into the analysis?
Into the,
So the testimony was that they were evading the officer, which would be before the initiation of the body camera footage. But I would argue that that goes into the officer's totality of the circumstances as to, is this individual armed? So that if you believe the officer's testimony, then you would find that the defendant did evade, and then when they finally did get him to stop, even though it would appear by body cam footage like that was quickly, that would be going into the officer's mindset of why is this person evading? And why is this person not putting their hands where they're supposed to? And why do I see furtive movements? So all of those things together under Michigan versus Long and under Terry versus Ohio would all go to the totality of the circumstances of whether that officer had a belief that the individual was armed and dangerous, and that would necessitate a protective sweep, not a search of the vehicle, but a protective sweep.
but the court would have the ability to not find that.
Sure. The court could, if there was a basis to find that it wasn't credible, but to say that it's not credible because it doesn't match the body camera footage, it wouldn't match the body camera footage because the camera hadn't been initiated at all.
Thank you.
And other than that, I would welcome my briefs, and thank you for your time.
Thank you. The court will take the matter under advisement and deliver a decision in due course. When that decision is reached, will be mailed to you by the clerk of court and also be available on the Ohio Supreme Court website. With that, on behalf of the court, I thank both of you for the presentation this morning.